Hi, you're welcome back. This is video number 4, and it's on the law of contract, and it's on this channel under the educational part, and we're dealing with the law of contract. So I'm going to try and give it the way the ordinary person asks about it, rather than the way it's taught in university. The first thing to remember is a contract for land has to be in writing. Other contracts don't have to be unless there's a reason for it. So if you're buying land, it has to be in writing, a written contract. And if you're buying, we say a car, it doesn't. Or if you're buying something, unless it's stated somewhere in law that it has to be in writing. So you can buy a horse or a chainsaw or anything else, and you don't have to have it in writing. And you can buy a bicycle of somebody, okay? So, but the land has to be in writing. The next thing to remember is that there's no such thing as a house in law. It's the land the house is on. Understand that? There's no such thing as a house, a building or a shed. It's the land the house sits on that is exchanged during a contract or a sale. Okay? Now, we now look at the contract law, and it applies in Ireland, England, Scotland, Wales, Northern Ireland, Canada, United States, Australia, New Zealand, and parts of the Caribbean. In other words, anywhere the British tramped around in their red coats and their muskets, the common law applies, and it was carried over into all those countries, especially those ones that became independent. They still use it because it's so basically common sense that you wouldn't even think of changing it. And I think it may apply in many European countries as well, but I won't go into that because I'm not too sure. Now, the first thing to remember is an invitation to treat. You see a state-of-the-art car worth 55,000, we'll say, and it's up for sale in the window at €5.55. Somebody made a mistake. And you go in and you demand the car, you put your €5.55 on the counter. Do they have to give it to you? No, that's an invitation to treat. If they had to give it to you, the expense of making sure every notice was correct would be too much. It would interfere with commerce. So that's an invitation to treat. Come in and look around and we'll talk about it. Understood? So if something's advertised at a particular price, nobody has to stick with that price. Usually they will if it's something for sale at a certain price and you pay that, you'll get it. But it's an invitation to treat. Get to understand that. An invitation to treat. Come in and look around. It has no legal status. Okay. Now, the next thing then is, when does it become legal? And that is when there's an offer. An offer is either made by the vendor, the person selling. Well, that's a mistake with that notice, but the actual price is 55,000. So I'll tell you what I'll do, what you give me. That's still not an offer. Your man says, well, I'll tell you, I'll give you 45,000. That's an offer. Whoever makes the first offer of exchange makes the first offer. That's just an offer. That has no legal status either. The next thing that happens is a counter offer. Well, I'll not take that, but I'll tell you what, I'll take 52 for it. That's the best I can do. That's a counter offer. So there's been the offer, the counter offer. Well, I won't give you 52,000 for it. Tell you what we'll do, we'll divide it. 49.5. No. But that's a counter offer. That's a third counter offer. Tell you what, 51.5, the best I can do. That's a counter offer. Well, I'm not going to give you €500 on top of the price. You either take even money or not. That's a counter offer. That suggests 50,000. And your man does a bit of grumping and contrarian. I'm making no money. What can I do? I'll do it. I'll take it. He probably has plenty of profit on it. The minute he says I'll take it, that's an acceptance. So you have an offer, a counter offer. You have an acceptance. He's now accepted the offer. The first person to accept the offer creates the first step in the law of contract. Offer, acceptance. The next thing then is that acceptance has to be communicated. There has to be some way of getting the other party to know we are in a deal situation here. And so the acceptance has to be communicated. And it can be communicated by saying it, by an invoice, by a bill of sale, whatever. That signifies the agreement. In a cattle mart or an auction, putting down the hammer. In fact, nothing really is legal in a mart or an auction until the hammer is struck down. And even then, there may be terms and conditions, there may be a waiting period, or there may be something, okay? But the hammer communicates the acceptance of the mart on behalf of the buyer. And there could be complications, it depends on the conditions. You'll see the conditions up. But in the case of the car, the seller, garage, has said, we'll take it. So that's it, that's accepted. Now, if the acceptance is by post, the postal rule means that the acceptance takes place when the letter is put in the box, in the post box. And this came up in a house fire case in London, where an offer of insurance for fire was accepted and posted on a Friday evening of a bank holiday weekend, and didn't the place go on fire over the weekend. And when the insurance company opened the post on Tuesday morning, they got the acceptance of their insurance policy. And they tried to avoid paying because they said weren't communicated until Tuesday morning. But the Henry VIII wanted the post to be primary. It was the legal system of communication, and he said it's when it goes in the letterbox. And so the postal rule means that if the timing of the communication or the acceptance is essential, it's when it goes in the letterbox, not when it's received. Okay, wouldn't be that many contracts accepted now by post, but there's no harm to understand that postal rule. That still applies. So now we have the offer, the counter offer, the acceptance, the communication of the acceptance. Okay, the next thing is the consideration. How much is being paid? And the courts don't want to be valuers, but they will not accept a real token, like €1 for the new car, even €5 for the new car. That's not adequate. So the consideration is what they call it. It has to be adequate but not sufficient. Adequate but not sufficient. So 16,000 for the new car would be probably adequate. It's a good lot of money. And it'd mean that there was a good deal of thinking gone into it. And obviously 45 or 50,000 would be completely adequate. That would be both the adequate and the value of it. But the courts do not want to be valuers. Courts do not want to be valuers. They just make sure that the consideration is adequate. So that's self-explanatory. If it was a bull-up today, 2-year-old, well, he's worth maybe 1,500, 1,600. I mean, you couldn't sell him for €40. That would not be adequate. But 600 or 700, 7 or 8 would be. It's adequate is when it's enough to concentrate minds, that there's some wee bit of pain to be part of it. Whereas sufficient is the actual value, and no court is going to get into what's sufficient. Okay, so once there's a decent price or other exchange named, it's adequate. So now we have that concept. We have the offer, the acceptance, the communication of the offer. The consideration must be adequate, but doesn't have to be sufficient. The next thing is the intention to create legal relations. There has to be the intention to create legal relations. So if there's some bit of tomfoolery going on, or somebody's cracking a joke, or it's a party and someone says, I'll sell you my car, that's not. There has to be an intention to create legal relations. And you often hear about quarries and businesses being sold by drunk owners in the pub. That will not stick. That is not an intention to create legal relations. So there has to be the intention, a serious intention, and that's taken from the facts of the case. So that makes common sense as well. Has to be a wee bit of seriousness of it. Now, one of the ways that used to be used was a deposit. I'll give you €20 as a deposit. That shows an intention to create legal relations. It's not necessary to pay a deposit. Not necessary. But it does put beyond doubt that there was a deal. It does seal a lot of things. It shows there was an offer, there was acceptance, there was a communication, and there was a price fixed, and that it was €20 was paid as a deposit. So it's an earnest, as they call it, Not essential, but it is in earnest. Okay. Now, so I think that's all the things about it. Offer, acceptance, the communication of the offer. If it's a post, done by post, the postal rule, it's when it goes into the box. The consideration has to be adequate, but it doesn't have to be sufficient. There has to be the intention to create legal relations. Then there's stuff called duress. You can't make a child sign away something if they're too young. There has to be the ability, they have to have the capacity to decide on the contract, and they have to be legal age, and there can't be duress or force or somebody threatening somebody or something like that. So that's why when these thieves go around and they force people to give them money, I mean, that's robbery. They'll go to jail for that. That's not anywhere legal at all, because it's duress. Now, I think I've covered everything there, and just to understand that. And the other thing then is that's amended by the several statutes deal with this, and I won't be able to go into them all, but one is the Sale of Goods and Supply of Services Act 1980. That's the Irish Act, and it followed the similar British Act in 1979, and it deals with spare parts and cars and all that. I'll just read out what it says in relation to this. In a contract for the sale of goods, there is an implied warranty that the spare parts and adequate aftercare service will be made available by the seller, and in such circumstances as are stated in the offer, description or advertisement by the seller on behalf of the manufacturer or his own behalf, for such period as is stated, if no period is stated for a reasonable period. So that's and then there's power by the minister. Now, in all of this, if the seller draws attention to a problem with the car, a defect, or some part can't be found, if the buyer is made aware of it, that cancels out that requirement. So you can cancel out the act by making the person aware. But obviously, if he tells you this car has no spare parts and I'm looking for 50,000, you'd probably tell him you'll get 25. Should I for a minute something goes, it's no good. But you're told and made aware. Okay, that's that. So that's in relation to spare parts. In relation to now, in relation to a service, and this would probably apply to lawyers, doctors, and all that. So Section 39 says about a service that the supplier has the necessary skill to render the service. He has to be able to do it. That he will supply the service with due skill, care, and diligence. Basic common sense. That where materials are used, they will be sound, reasonable, fit for purpose for which they are required. Okay. That where goods are supplied under contract, they will be merchandisable quality, within the meaning of Section 14.3 of the Act inserted by Section 10. So Section 14.3 of the 1893 Act is still law, would you believe? They simply inserted the Section 10 of the 1980 Act into it. Makes no difference. So that's the law in relation to offering a service. I think I've called that out fairly good. And it's Section 39. You can get it online. Okay. The next thing then is what is? Oh yeah, about goods. With goods, this is inserted into the 1893 Act as well. But with regard to goods, I'll just read a wee bit of it. Goods are of merchandisable quality if they are fit for the purpose and purposes for which the goods of that kind are commonly bought, and as durable as is reasonable to be expected regarding any description applied to them. The price of relevant and all of the other relevant circumstances of any reference to the Act to unmerchandisable goods shall be construed accordingly. So basically, the goods must be of merchandisable quality. Okay, that's fairly basic there. And if you're buying something that's damaged and they tell you about it, that's okay. So it's not too bad. It's a good bit of act. Now, there's a lot of stuff on that, and I won't go into it here because I'd make the thing too boring. But there's one little piece of law that's very important to understand, and that is in relation to employment. And sometimes you get a situation where a person takes up a job, we say, maybe 15 years ago, and there's a health insurance payment by the company. Maybe they're going to pay all or pay half, or there's some condition they give you. Now they give you some promise. That's binding on the company. That's part of their terms of employment, and they can't break that without your consent. And sometimes companies will be sold on to another company. So they'll try to get out of maybe their contracts, and the new company will come in. We bought this company over. We're now the owners. All previous contracts are gone. We re-employ you or whatever. And in some cases, they'll say, right, regarding your policy of health insurance, where we pay half, we're going to downsize it, and we're going to pay less, or we're not going to pay our part. That's the new management decision. And you get this letter in the post, and it's shocking, right? And what do you do with it? The Sale of Goods and Supply of Services Act doesn't seem to apply. And here, for once, and I'm not one to praise the EU law applies in. It's the Frankovic case. Frankovic case out of Italy, right? I don't have the number of it here. I should have got it before I started. But it's the Frankovic case. It's easily available online. And that prevents a new company of altering the conditions of service. And you write back and you say, you tell them what I've said here, the law of contract. The Sale of Goods and Supply of Services Act doesn't apply, but there is other employment law. And there's the Frankovic case. They can't get out of it. You cannot buy a company and scrap the rights of your employees by just buying the company and setting up a new company and making all these decisions. They'd love to do it. The Frankovic case from Italy. Okay. So that's it. Maybe at some stage in the future I'll give you the reference number of that case, but it's there. I use it and I know it's there, and so that's it. And it's one occasion where EU law does come in handy. I know people who have had their insurance, their terms of employment and all that reclaimed, where they were trying to take them away by quoting that case. So that's it now. And remember, this will apply. This applies in lots of things. We talk about accounts, so we talk about everything. But without a way of having a contract, it goes back millions of years. There was always a way of doing it. And so you have to have some way of having an agreement for the exchange of goods and services, etc. And that's basically it. So I hope there's some wee good in that. There may be a long time till this is viewed, but someday somebody might want to use it, and it'd be good to do it. So that's the law of contract. And we'll see you back here on Real True Educational, not fake news, whenever. It'll be video number 5 the next time. I don't know what it will be about. So, Gora Maigot, which is the Irish for thank you very much. Bye.